Today's session kind of came into our minds because there's so much hustle in the world right now about privacy laws. Obviously, there's a lot of hustle in Ukraine right now, but we still have to talk about privacy laws. And then we pray to God that everybody who's there in Ukraine is safe, especially Indians who are out there are safe. Coming back to our webinar, uh, today we want to talk about 4 new privacy laws in the US, what these laws are about, how are they different among each other. I know people here, I hope you're a bit educated about CCPA, CPRA, and then we will get into something about New York, something about MIT, right, and stuff, and go on and on and on, and then kind of conclude this session for you today. Before starting, a bit about me. My name is Akash Singh. I am a fellow in information privacy, CIPP, CIPM, CIPT, CEO and co-founder of Saro Academy, Saro Labs. I'm a privacy professional profession. I know a bit into privacy. I look into strategies in the companies, how privacy compliance programs are going to run. And also, obviously, because of Academy, I'm also a trainer, right? So you see me training sometimes. Yes. Okay. Moving on to our special guest today and a very dear friend since he started his career, because I started my career a year ago for him. So basically, dear friend, right? Shashikant Akhilesh is on the call. Shashikant Akhilesh kind of comes in with exactly the same experience, plus more than me, because he has been there and he has been into corporates, he has been into financial institutions solving privacy problems from a corporate governance level, right? Exactly what a privacy professional will be doing in India internationally right now. So he sits at the best place to tell us today about privacy laws, about new laws, what should we think about, what should we do in our companies to prepare for them. So over to you, Akhilesh, for a short introduction.
Hi everyone, I'm Akhilesh. I'm currently working with PwC as a senior associate, so which is equal to assistant manager over there. And I'm an FIP, just like Akash, and I have completed my CIPPE, CIPM, and CIPT. And I'm targeting CIPP US too. And I predominantly work for GDPR and implementation of US laws across multiple organizations, like right from implementation, doing audits, doing testing, everything. And we also help them in terms of how they need to comply with all the privacy laws. That's my brief background. And predominantly, I work for banking industry and also IT industry.
There's a pretty difficult experience to have in today's market, right? Because there's this joke running around, right? Actually, it's that everybody talks about privacy, but nobody knows about privacy, right?
Exactly.
Nobody has done no projects, no privacy strategy, but everybody's in a privacy expert. So I think if you want to be a privacy expert, the biggest thing that you need to have is experience. You need to have the right certifications, right experience, right knowledge to implement anything. Because privacy strategy changes everything in the company, right? It changes everything. It brings in cost, brings compliance. So it has to be right. And that's exactly where Akhilesh comes in and also going to help us in understanding more. So a bit about Saro. We are a data protection as a service company, right? We looking into regulatory compliances like GDPR, CPA, on and on, Indian PDPB, right? We help organizations get them compliant. We help organizations with ISO 27001, 27701, SOC 2 certifications. We support a lot of consulting work from Saro. Yeah. Okay. So I think we talked about a lot of introduction today, right? But I think coming on to what we are here for, the agenda for today is about US privacy laws. We're going to talk about California Privacy Act and not CCPA. We're going to talk about Colorado Privacy Act, CDPA, Virginia, New York Privacy Act. And then we're going to talk a bit into, if we have time, obviously, then we're going to talk about EU versus US. So now the question, do all the states within the United States have an established privacy law? That is my question to all of you. Do you think that all the states in the United States, or do you think that there is a federal law in US, just like EU, where the same law applies, the regulation applies everywhere? No. Okay. Okay, no. Nope. Okay, nope is a better answer definitely here today. No, not yet. Yes, exactly, guys. Right. That's the best answer. Okay. So let's moving on, right? So let's talk about a few timelines in the past, right? I think before whatever we do in the future, we look at a bit of history. So people ask me, Akash, are the privacy laws new in US? They are not. Were they new in Europe? they were not. US Privacy Act came in 1974. HIPAA, everybody knows about HIPAA because the moment you have PHI, personal health information, the next moment HIPAA applies to you if you're in the US. Came in 1996. GLBA 1999. COPA 2000, right? And all these acts passed before even thinking about GDPR. That's what we think about, right? GDPR came in, and now because countries need adequacy, so they are going after one by one to do business in EU. They're going after laws. Okay, right. Let's look at the elephant in the room. We have reached California Privacy Act. So my question to Akhilesh is, Akhilesh, how do you see the CCPA being different from CPRA?
Like if you'd have seen CCPA, right, the way the CCPA has been drafted and been implemented, that's what we say as an organization specific. Now there are more rights to the consumer. They are giving specific conditions when they can process, how they can process. They have implemented the conditions like purpose limitation, specification, storage limitation. So they're coming up with more consumer specific. So that's something like they are moving towards, like all the US state laws. And they also given specific conditions when they can process, to whom they apply. So it's more clearer and organizations can understand where what is applicable to them and how they need to act and what are the penalties. It is very much clearer here in CPRA. So it's like an upgraded version for CCPA, better for consumer.
Sure. I think talking about CCPA and CPRA, we're talking about more depth. But Akhilesh, would you also like to talk a bit about what CCPA was, right? And I kind of see, I kind of start talking about laws through an applicability matrix, because the moment all the privacy laws kind of come back to the similar privacy checklist, consent management, DSARs, right? But how do you think, on which businesses CPRA or CCP applies, Akhilesh?
Like if you see CPRA, the condition to which CPRA will be applicable, they have come up with this condition for the revenue, right? So if they're earning more than half of its annual revenue from selling its customers' data, right, CPRA will be applicable. So if an organization which predominantly process customer information, or an organization which depends on customers information or consumers information, CPRA will be applicable. So it's a kind like restricting the consumer, like the organizations, to sell the data. So if you're an organization who predominate like an e-commerce or any other industry who deals with a lot of personal information, right, like if you're having more than 50,000 consumers, right, so for large organizations it will be applicable, and wherever, if it's a smaller organization, they are given a provision that will not be applicable to them. So it's targeting the bigger organizations like e-commerce, healthcare industries, business which predominantly deal with consumers, your retail websites and everything.
So basically, if you look at it from an angle of GDPR, where the law applies to all the organizations, do you want to say that in CCPA or in the US, the laws are more centric towards companies which sell or buy data?
Exactly. So, like if you see GDPR, right? GDPR deals with entire data set. It's not doesn't differentiate between a consumer or a employee or a like contractor. It doesn't differentiate. But whereas if you see CCR, like CPRA or your California, Virginia Data Protection Act, right? They tend to differentiate between consumer and the employee. So it's not applicable to all the data sets. It's only specific to the consumer. Wherever you're purchasing particular, like what we say, any goods from there or obtaining any services from them, then only this act will be applicable. If you are a normal citizen, then this act will not be applicable unless the organization deals with large sets of personal information. So that's a huge difference. So most of the acts here, that doesn't talk about employee safety. Employees data is still not covered under these acts.
Right. I think setting the tone straight, I think makes a lot of sense, that customer data is the only data that will come under. I think I've read a lot about these laws, especially in the past few weeks, and all the laws kind of direct similarly, right? Where it's everything talks about PII, customer PII, right?
Exactly. It's
So
only
I
consumer
think
PII.
SPII is a new term that got added out in CPRA after CCPA. So that has happened. So just want
That's
to let everyone know about that. Okay, so summing this up, right? So I think CCPA is active in US. CPRA will become active, will overtake CCPA,
right.
right, on 1st Jan 2023. So people have what, like 9 months, I think, from now, 9-10 months, where that thought process of compliance needs to change from CCPA to CPRA and be compliant. right? Okay, so the applicability of the act is any one of the three, right? If you are doing business inside California for residents of California, and you have half of the revenue that you earn is from selling consumers PII, it will become applicable. If you buy or receive PII of 550,000 consumers to obtain revenue, you come under CCPA, CPRA. And if your business has excess of $25 million, right, it again applies, right? If gross revenue is in excess, you're still under CCPA. So
That's
CCPA
one
right now,
point, right? Like if you're by default, if you're having a revenue more than $25 million, you're by default be under CCPA, irrespective of what you're doing.
yep. Guys, if you have questions, keep dropping them, right? This is a webinar where we just want to straight talk about the laws a bit into perspective and applicability, right? So that we can understand which laws apply to us. Even if we are a company in India doing a business in US, right? Would these laws apply to us? We're talking about that, yeah. Colorado Privacy Act. Okay. So the law was enacted on 8th of July 2021. The effective date is 1st of July 2023. So all the companies in Colorado, or if you're doing business in Colorado, the applicability matrix may come very close to you. So keep a watch on this. So Akhilesh, let's talk about a bit about Colorado privacy. Would you like to give us a brief about the act and the type of applicability kind of comes across?
Like if you see Colorado Privacy Act, they have taken most of the definitions from this California's Act, right? So whatever when we say sale of data, or like whenever we are collecting consumers' data, they have taken pretty much the same definition. They adopted them. However, it's like even the applicability part of it, if you see, it's very much similar. It targets only the Colorado citizens, or if you are residents of it, or if the industries or the organization is trying to target those citizens, then only it will be applicable to them. Even here it's very similar. They have excluded the employees data. It's only applicable to consumers data. But if you see in terms of strictness, CCPA is much more stricter when compared to Colorado Privacy Act.
I think Colorado kind of is starting with the journey, just like California did. So I think that is
Right.
also a pointer. But just to let all of you know, there are conversations that are happening between US and EU for a new privacy shield, or they may call it something else. But that
Shield,
may,
right.
yeah, there
They call it
that
a Shield
also,
Act. Yeah.
yeah, that also may come soon. I think that conversation is happening. So we can see something around that and a federal regulation around that. But yeah, we're just waiting for it, and but something has to come to solve that bigger gap and umbrella. Again, Akhilesh, what do you think is the applicability metrics for Colorado Privacy Act, and what is it that people need to keep in mind that this act will apply to them?
Like by default, if you're having a business setup in Colorado, it will be applicable to you. Or if any industry outside of the Colorado but targeting Colorado citizens, it will again applicable to you. Or if you're processing consumer data like 1 lakh data, 1 lakh and more, then by default you will be under CPA. And if your revenue, instead of percentage, they have defined in absolute numbers. So if you're deriving revenue from selling of consumers data, then it will always be applicable to you. So that's the difference between your California Act and your Colorado Act, where this time they have, instead of percentage, they have defined the number.
Yeah, we have a few questions, all right, and I think especially the questions are coming around the applicability metrics here in CCPA.
Right.
So basically, question number one to you, Akhilesh, is if the business turnover is above $20 million, $25 million, will the CCPA be applicable to any company?
Right, it will be applicable. I'm
Okay.
talking about a private sector. Public agency is a completely different ballgame. But if it's a private organization, if your business is more than $25 million, by default it will be applicable to you.
And do you think that when this CCPA will apply, employee data will not be considered under CCPA because the law doesn't regulate that, right? Am I correct?
Right.
Okay. Now, the question number two, I think this is a great question, by the way. The question says, what is the exact goal from moving on to CPRA from CCPA? Why would California move on, change CCPA to CPRA? Do you
Like if
have?
it has seen the way CCPA has evolved, right? Only California was the first constitution to recognize privacy in the US, right? So they were given constitutional right for privacy, and later on they have come up with CCPA. But that was a very old act. It doesn't talk about the rights. It's not extensive rights like GDPR, right? If you see CCPA, it only talks about how we sell the data and how do we need to control it, but it doesn't give much rights to the data subject. Now, if you see CPRA, right, it has give much more consumer centric, like it gives more rights to the data subject on how, and mandates the notice requirement, mandates website requirements of do not sell personal information. It asks the organization to reveal more information to whom they are selling, where the data is residing, and asks the organization to protect information, right? So it's more, they're evolving to the technology needs, and that's why there's the requirement for the new act.
So I think Gaurav has a question for you, Akhilesh. If Indian organizations,
Mm,
an organization from India,
mm.
is dealing with California or Colorado businesses, right? Will this act be applicable to an Indian organization?
Right, it will be applicable if you're targeting. So targeting in the sense you're like sponsored advertisements through Facebook, LinkedIn, or any other social media, or your posters, right, or newspaper if you're targeting them specifically for the business, then it will be applicable to you.
Okay, question number two. So many privacy laws coming from various different states in US. What are the challenges that an organization is facing with respect to adhering to all of these laws? How can, let's say, a global organization, right, or let's say an organization that is very huge in India, does business in all the states of US, and every state has this new applicability, new matrix, then how do you solve it, Akhilesh? And I think this is a question about a global compliance matrix as well. So how do you go about it?
So like, leave US aside, even if India targeting a state like in European Union, right? There are multiple states, and every state has a different requirement. Like someone has a registration requirement, or someone might be having a constraint in terms of minor age, right? So this is a common problem across all privacy requirements. Like there are multiple regulations, and we need to comply with each regulation. So what we can do as an like privacy strategy is that we try to identify the commonalities. Like if you see CCPA or your Colorado Privacy Act or your Virginia Data Protection Act, right? We try to identify the commonalities first thing, and we try to come up with a common solution for that. And wherever there's an outlier, like for example, DPA might be coming up with an additional right to modification or right to deletion, right? Whatever outliers are there, we deal it individually. So try to find the commonalities across all the laws, implement it with a common solution, and wherever you want to there are outliers, then deal with it for that particular state. Especially in terms of data subject rights, right, the timelines will be varying from each and every act, and the number of data subject rights provided to each company will be like each data subject will be different. So we, in respect to that, try to find the stringent one and apply it all to all the nations of all the data subjects. Then you'll be, by default, you'll be complying with all the regulations. That's one way you can comply with the global regulations. That's what we suggest to any organization in terms of dealing with privacy.
I think very fairly put forward, right? I think one more question is left. Okay. Can we say if a company has GDPR considerations and compliance in place, would that cover CPRA requirements already? And if not, how should a company who's already compliant with GDPR should approach CPRA?
Right. So for to the first question, right, if you're compliant with GDPR, by default, you'll not be compliant with CPRA because the requirements are completely different. Here we are talking about consumers and mostly towards consumers' data, right? And there the rights, the what they talk and the website requirements are completely different from GDPR. So by having GDPR, you'll be compliant with the security requirements, the way you protect the data, and way the GDPR data minimization principle or the other GDPR principles, you will be compliant. So 50-60% you are compliant, but there are additional requirements for CPRA. So that requirements like publishing a leak on your website, or the way you share the data, sell the data, right? GDPR doesn't generally allow to sell the data, whereas CCPA allows to sell the data. And it also allows you to provide discounts to the consumers who provide their personal data, right? That's against GDPR, right? So these kind of things will be different. So we need to approach those outliers case by case basis.
Moving on, I think great questions, right? I think this is what we always are looking for, right? Please drop your questions. Whatever you're thinking, no question is a small question. All questions are good questions. Keep dropping them. We'll take them up. Okay. So Consumer Data Protection Act, Virginia. Now we're talking about the state of Virginia, right? So Akhilesh, first of all, what is this act and then when is it getting applicable and what is the applicability? Yeah, over to you.
So Virginia Data Protection Act will be effective from 1st Jan 2023. So we have about 9 months for compliance, right? And very much like that's the trend that's happening with the privacy laws, right? Everyone is defining personal data. Now they've included sensitive data as well in terms of Virginia Data Protection Act. Now, in terms of Virginia Data Protection Act, it sets the consumers like similar to the GDPR principles. It also has defined the principles in which the controller has to act. Again, that has also provided exceptions, like when you're transferring the data to processors or your subsidiaries or your close entities. In that cases, there are provided some exceptions, but overall, it's in terms of protecting the consumer's data, right? Like your European GDPR, there are additional rights that are provided to the data subject, like your right to access, correction, deletion, and like you have also have this option of opt out of processing. So this kind of rights have been additionally included in your CDPA.
Yeah, makes sense. So again, deadline is coming and 10 months more to go. We'll see how that fares out for the organizations who are doing business over there. Applicability matrix, Akhilesh. When will Virginia Act apply or not apply?
Virginia CDPA is very much similar to your CPA, Colorado Privacy Act, right? It defines the number of consumers. It's 25,000, more than 25,000 consumers, right? Or if you're selling the data, you're targeting Virginia state people, right? Residents of Virginia state, by default, it will be applicable. Or this time again, it comes back to the percentage. If you over 50% of your gross revenue is coming from sale of personal data, right? So all these acts, all the US acts talks about sale of consumers data. It doesn't talk about employee data or your other data that you are collecting as part of your businesses. It's consumers, and if you're selling those data, that will be applicable to you. And if you're processing more than 1 lakh consumers during a calendar year, so that's a strain. If you're more than 1 lakh consumers you're having, then you by default you need to be compliant with the Virginia Data Protection Act. So when we say you're processing, even if you're storing the data, it will be applicable to you. So if you have a customer base more than 1 lakh, by default you need to be compliant to this act.
Yeah, I think that's kind of fair enough to kind of answer. But I have a question for you, Akhilesh, and this question is a very pointed question, and this is a very good question. If an organization is already compliant with Trust, privacy, CPR, Privacy Shield, though Privacy Shield is invalidated, but still APAC, privacy certificates, we need to know more about what type of certificates are we talking about, because a certifying authority is still not there. But still, let's say that APAC compliance is done, privacy NIST compliance is done, right? Now, after doing all of this, would a company still require a readiness assessment looking for GDPR, CPRA, Virginia, right? Do you think we still need that readiness assessment, Akhilesh?
Right. See, if for example, if you're compliant with NIST, it talks about takes care of your security requirements. If you talk about each, right, it has a certain condition targeting. Someone will be targeting the cross-border data transfers. How can you transfer the data? Someone will be talking about your data subject rights. That's why when we talk about privacy readiness assessment, each regulation has its requirement. So doing your privacy readiness assessment is the only way we can identify whether you're compliant with all the regulatory requirements or not. So I suggest for each law, do your regulatory assessment, then only you'll be able to identify how much you're compliant with it. You cannot say by compliant with one regulation, you're compliant with all the other regulations. That will never work.
I think privacy is one of those things that, it always kind of,
It's always evolving, it's always changing, right? Even GDPR, after having a mature privacy policy, right? It evolves for a period of time. There are new ways we interpret the data, right? Even for now,
yeah,
for
even
US, it's going to have a lot of changes. That's what is
definitely,
expected.
definitely. I think one more thing that kind of keeps me awake at night, right, is the fines that are running. So especially for me, because I'm working with a lot of people in Netherlands, so I'm always looking at the Dutch DPAs, type of fines that are coming in, because one of the fines that happened last time was TikTok, right? Very famous fine where the privacy notice was not in Dutch, right? But
Right.
we still know that 95% people in Netherlands speak English. But still, the notice was not in Dutch, and henceforth, a fine was given. So, and then such things can keep coming up because there are small organizations, medium-sized organizations, and everything cannot be achieved, right? So we have to get closer and closer to compliance.
Adding on to
No,
that, right, like more and more consumers are getting aware about the privacy laws, right? So more and more cases are being filed at the international courts, and this is where the case laws are coming from. So the way they were interpreting previously is completely different. Like 2 years back, how we dealt with GDPR is completely different between now how we are dealing with GDPR. There's a lot of change how we are exactly like keeping the compliance for the organization.
so high trust only focuses on privacy. Yes, Ashay, you are right. Right, definitely, you have a fair point over there. But yeah, but it depends. I think just want to kind of add in, no privacy framework is the right privacy framework for any organization.
Right.
Privacy, I kind of say that, privacy is like aloo, right? It's like that potato, right? So वो सारी सब्जियों के साथ जाता है, right? It goes with all, whatever you're making, right? You can put some privacy over there. But the problem that has started is, you cannot now, if you treat it like that, you cannot miss potato, because potato is the main ingredient now, right? Because that is privacy for you, right? Okay, so let's talk about New York Privacy Act now, Akhilesh, right? So
Right.
though it's currently on hold, right? But it's still very closer to CCPA. So I just want to
Right.
talk about this as well. If it comes, right? If it comes, and obviously New York being a state, right, one of the biggest states, right, and the most people do a lot of business in New York, especially in India. How do you see it going forward, right?
Right, like rightly you mentioned, it's very close to CCPA, right? But few things are little different in terms of New York Privacy Act. If you see the consent mechanism that's coming with New York Privacy Act, it's opt-in consent, right? That's very similar to GDPR. Whereas if you see your California, it's opt-out consent, right? So that's a very major difference in terms of US. So this is where I think it's going more towards the federal laws. Every state wants to be compliant with privacy, and this in turn will lead to the federal law for privacy in US. So in terms of applicability or in terms of new things, right, they are given various rights to the data subject. This time they are given right to access, right to port your data. So this is something, again, we need how the porting will be applicable, how the data can be transferred from one organization to another organization. Now the compatibility between the two organizations will also come into picture because of this right to portabilities. So we are awaiting for more guidelines on how this will come and what is the implementation requirements. But still, this is an additional requirement when compared to your typical CCPA, right, where we can directly sell the information. Now consumer can request for porting, so that's one more difference. So in terms
So
of
yeah,
applicability, right, jurisdictional requirements, if you are having your annual gross revenues of at least $25 million, again, so irrespective of which industry you're dealing with, if you're having more than $25 million, it will be applicable. Or if you're selling your consumer information and getting more than 50% of your revenue because of that, then again it will be applicable. Or if any entity is targeting New York residents, then it will be applicable. Or if you're conducting your business in New York, it will be applicable. Or if you're processing information of more than 1 lakh consumers, then again it will be applicable. So the applicability part of it is very much similar. Either you are conducting business in that particular state or targeting those residents, or if you are getting revenue from them, by default it will be applicable. So that's how the US
yeah,
laws have been.
yeah. By the way, just want to tell everyone as well, just a small message. We have created a privacy readiness assessment test, right? You can just go over there. It's in the chat. You can just click on that and just assess, right, your organization's current privacy stature, right? With whatever, it just takes 2 minutes, right? We have been working on this. This was our private pilot project last month, and we kind of found it helping a lot of our clients. We just made it. Just go online, right? It's not that comprehensive, but it will take less time, and you can get some answers out of this, or maybe think about what type of things you need to focus on. Okay, so this question is for all of you. Are the rights provided to consumers uniform across the four laws? What do you think? Do you think the rights provided to consumers are uniform across all the four laws that we discussed today? Yes or no? So what do you think, guys? Do you think that the rights are similar, or do you think there is a difference? And when there is a difference, and especially when we talk about things as small as opt-in and opt-out, whole infrastructure of a product changes. The product infrastructure has to change to support that. And it's not, and I know people who are here and who are related to product development, we all know how costly that thing is. and the amount of cost that gets involved in product development and the type of things. So basically, let's take an example of Airbnb, Booking.com. If you're in India, Facebook, right? If you're in India, if you can give consent, your data is treated differently. If you're in Europe, you give consent, your data is treated differently, right? So indirectly, what it means is, if you're in India and if you give consent or do not give consent, they do not care, right? Because we don't have a law. But if it's now, think about it. Think about it this way: that if now we go back in consent mechanism, go to US, go to different states, the state-wise regulations need to apply. So especially it will go to Airbnb, Booking.com. So it's getting difficult and more complex, and especially the new Indian companies that are going to US like Boyo, right? The complexities are just increasing for them. Okay, so coming back to our comparative analysis. Thank you for answering. You guys were right. The answer is yes. Okay. Let's do a quick comparison and then we will drop off. So, Akhilesh, would you like to kind of summarize these rights, right? How is it different? What is different? What is exactly the same, right? Yeah.
Right. If you see all the four acts, right to access is very much common. So that is one thing. Everyone has this right to know their information. What is it? And every act is mandating that if there is any mismatch with the information, if there is requires a correction, the data subject has this right to keep it as correction. So this very much in line with GDPR, right? Where right to accuracy comes into picture, right? So right to correction, but right to appeal is something New York Privacy Act doesn't come up with, right? So you cannot go to an authority to asking them to update this information, or if you have any issues with the processing, the right to appeal is not available. Again, right to data portability is something that is not applicable in all the regulations. Right to opt out is there, so more rights to the data subject, and right to delete is available, but right to delete prima facie is available in all the four regulations, but the conditions in which right to delete is applicable is different in all the four. So that's again we need to take care while implementing at organization level.
Moving on to penalties, I'll just take this up, right? So penalties in CPRA are somewhere around $2,500 to $7,500 if you complain. I don't like talking about penalties in the US a lot because US is a state which is governed by lawsuits, right? So the problem in US may not be that whether an authority will fine you, right? That is why the authority fines are not that much. It's $15,000 for New York, $7,500 for CDPA, CPA, even something more than that. But the thing is, if you don't follow a law in US, a user can send a lawsuit to you. And that's exactly what happened. And settling lawsuits becomes very difficult. Lawyers are very active in US, and being a capitalist economy, right? You can understand what happens when you don't follow that law. People will find issues and send you stuff. Okay. So, okay, last question. Are
Akash,
US
just one point to add, right?
yes,
In New York, it's $15,000, right? But that's per violation per customer. Like if there are 10 customers you have violated, that will into 10 directly. So that's a huge fine that we are looking at. But it depends upon type of violation you're doing again, but still.
definitely. And I think what I'm trying to put in as well is that is already a lot, right? But the problem in US is you also get a lawsuit, right?
Right.
Per customer, you're getting a lawsuit per customer. So that is not a country to play with in privacy, right?
Exactly. And class action lawsuits are very much common over there.
Yeah, it's very common. So if you honk somebody and he's not happy, who knows, right? And we're talking about privacy now. So let's get serious here. Okay, I think everybody's kind of answering no. So you already know the answer. So we are good with this. So guys, we're going to talk about this, but we're going to open the session for Q&A in 2 minutes. So now my thought to you is whatever questions you have, right? Anything that you want to ask us, drop a text in the chat in Q&A and let's talk about it, right? It can be privacy, it can be an implementation, it can be Q&A, DSAR. Just drop it in the text. We'll talk about it, right? We're coming back. So Akhilesh, can you quickly wrap up for us how EU is different than US when we look at the privacy laws? Yeah.
Right. So EU is more like a federal law, right? It deals with entire data, whereas US is more sectoral law. It talks about sectors. Like if you take healthcare, it's HIPAA. We have for children, it's COPA, right? So everything is sector oriented. For finance, it's GLBA Act, right? So it's more sector oriented. And now they're moving to a trend for state oriented laws. For every state is coming up with their own privacy law. We have discussed four here. There are other couple of laws that are coming up in US, right? So it's more state oriented. We are expecting that it has to come from a federal point of federal law, but still it's a long time it is going to take for to come up with a federal law. But each state is having its own requirement. So for an organization, it's very messy because we need to comply with all the different state laws that we need that are applicable to them. Wherever we are serving, there we need to be compliant with that particular state law. So that is something that we need to take care of. And if you belongs to a particular sector, again, the particular sectorial laws will also come into picture. So you're dealing with multiple laws here.
Yeah. After that, I have got a very good question. Yeah. So let's go to questions now. Right. Let's go to questions now. So any Indian Privacy Act and violation doesn't. Gaurav, can you like put more light? I cannot understand. So basically, if we talk about violations, right? So we can talk about non-compliance. So at least, where do you think we are in India with the upcoming law, and how is non-compliance being charged? Right. So what do you think about it?
Indian penalties are very much on the higher side, just like the GDPR. They're coming up with similar kind of requirements, like 2% or 4% of worldwide turnover. That is what we are looking at in terms of Indian privacy violations, right? So again, that's a huge amount, but the effectiveness, right? The way the data subject can reach out to the authority and file a complaint is something that we need to look at in India. In Europe or in US, it's very easy for the common man to go to the code of law, but in India, that is not so common. We have an apprehension to go to the code of law, right? So that is something. So violations is something that we need to look at and how effectively we can implement it.
So makes sense. It was a great session. It was great time hosting all of you. Right. I hope there was some knowledge that we imparted you. Thank you for joining the session. Right. And Akhilesh would like to thank everyone as well.
Thank you everyone for joining the session, and it was very nice interacting with you, Akash. Looking forward for other sessions too.
Yep. Sure, guys. Have a nice day. See you
Have a
then.
nice day, guys. Thank you. Bye bye.